Jurisdiction of family courts in civil cases. Family courts have exclusive original jurisdiction over petitions for guardianship, custody of children, and habeas corpus in relation to the latter. Petitions for adoption of children and the revocation thereof. Complaints for annulment of marriage, declaration of nullity of marriage, and those relating to marital status and property relations of husband and wife, or those living together under different status and agreements, and petitions for dissolution of conjugal partnership of gains. The family courts have exclusive original jurisdiction over petitions for support and/or acknowledgement. Summary judicial proceedings brought under the provisions of the Family Code of the Philippines. Petitions for declaration of status of children as abandoned, dependent, or neglected children. Petitions for voluntary or involuntary commitment of children, the suspension, termination, or restoration of parental authority, and other cases cognizable under PD number 603, EO number 56, series of 1986, and other related laws. Alright, the family courts have exclusive original jurisdiction over petitions for the constitution of the family home. Family courts have jurisdiction or have authority to issue special provisional remedies, including in cases of violence among the family members living in the same domicile or household. The family court may issue a restraining order against the accused or defendant upon verified application by the complainant or the victim for relief from abuse. Another special provisional remedy is the court may order the temporary custody of children in all civil actions for their custody, support pendente lite, including deduction from the salary and use of conjugal home and other properties in all civil actions for support. Let's discuss habeas corpus. Does it fall under the jurisdiction of the Court of Appeals or the Family Court? This is discussed in the case of Madrinian versus Madrinian, GR number 159374, July 12, 2007. The facts of this case are as follows. Petitioner challenges the jurisdiction of the Court of Appeals over the petition for habeas corpus and insists that jurisdiction over the case is lodged in the family courts under RA 8369, Section 5B thereof. So, Section 5B of RA 8369 provides for the jurisdiction of the family courts, which includes exclusive original jurisdiction to hear and decide petition for guardianship, custody of children, habeas corpus in relation to the latter. So, the issue in this case is, what court has jurisdiction over habeas corpus cases? So, is it the Court of Appeals or the family courts? Citing Thornton versus Thornton, the Supreme Court held that the Court of Appeals should take cognizance of the case, since there is nothing in RA 8369 that revoked its jurisdiction to issue writs of habeas corpus involving the custody of minors. The court held that RA 8369 did not divest the Court of Appeals and the Supreme Court of their jurisdiction over habeas corpus cases involving the custody of minors. Okay, the provisions of RA 8369 reveal no manifest intent to revoke the jurisdiction of the Court of Appeals and the Supreme Court to issue writs of habeas corpus relating to the custody of minors. Correct. Okay, so the provisions of RA 8369 must be read in harmony with RA 7029 and BP 129 that family courts have concurrent jurisdiction with the Court of Appeals and the Supreme Court in petitions for habeas corpus where the custody of minors is at issue. The Supreme Court cited AM number 03-03-04-SZ, April 22, 2004, in re Rule on Custody of Minors and Writ of Habeas Corpus in relation to custody of minors, which provides that the petition may likewise be filed with the Supreme Court, Court of Appeals, or with any of its members, and if so granted, the writ shall be enforceable anywhere in the Philippines. Okay? From the foregoing, there is no doubt that the Court of Appeals and the Supreme Court have concurrent jurisdiction with family courts in habeas corpus where the custody of minors is involved. So what is the rationale of this ruling? The Supreme Court noted that after petitioner moved out of their Parañaque residence on May 18, 2002, he twice transferred his sons to provinces covered by different judicial regions. This situation is what the Thornton interpretation of RA 8369's provision and jurisdiction precisely addressed. Okay? The reasoning that by giving family courts exclusive jurisdiction over habeas corpus cases, the lawmakers intended them to be the sole courts which can issue writs of habeas corpus, so that reasoning, according to the court, will result in an iniquitous situation, leaving individuals like respondent without legal recourse in obtaining custody of their children. Individuals who do not know the whereabouts of minors they are looking for would be helpless, since they cannot seek redress from family courts whose writs are enforceable only in their respective territorial jurisdictions. Thus, if a minor is being transferred from one place to another, which seems to be the case here, the petitioner in a habeas corpus case will be left without legal remedy. Okay? This lack of recourse could not have been the intention of the lawmakers when they passed RA 8369, giving the family courts jurisdiction over habeas corpus cases where the custody of minors is involved. The court cited the same provision again of Section 5B of RA 8369, saying that a careful reading of that provision reveals that family courts are vested with original exclusive jurisdiction in custody cases, not in habeas corpus cases. Writs of habeas corpus which may be issued exclusively by family courts under Section 5B of RA 8369 pertain to the ancillary remedy that may be availed of in conjunction with a petition for custody of minors under Rule 99 of the Rules of Court. So in other words, the issuance of the writ is merely ancillary to the custody case pending before the family court. The writ must be issued by the same court to avoid splitting of jurisdiction, conflicting decisions, interference by a co-equal court, and judicial instability. Jurisdiction of family courts in criminal cases. Family courts have exclusive original jurisdiction over criminal cases where one or more of the accused is below 18 years of age but not less than 9 years of age, or where one or more of the victims is a minor at the time of the commission of the offense, provided that if the minor is found guilty, the court shall promulgate sentence and ascertain any civil liability which the accused may have incurred. Family courts have exclusive original jurisdiction over cases against minors cognizable under the Dangerous Drugs Act. Violations of RA 7610, otherwise known as the Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act as amended by RA 7658, and cases of domestic violence against women and children. Let's discuss a case where some of the murder victims were minors. People v. De La Torre, Yadaw, GR number 162144254, November 13, 2012. The basic fact in this case is that 2 of the murder victims were minors. So the issue is whether or not the executive judge should have raffled the cases to a family court pursuant to Section 5 of RA 8369. The Supreme Court held that it is not impervious to the provisions of Section 5 of RA 8369 that vests in family courts jurisdiction over violations of RA 7610, which in turn covers murder cases where the victim is a minor. So RA 8369 provides that family courts shall have exclusive original jurisdiction to hear and decide cases where one or more of the victims is a minor at the time of the commission of the offense. So in this case, investing the family court's exclusive original jurisdiction over criminal cases involving minors, the law seeks to protect their welfare and their best interests. For this reason, when the need for such protection is not compromised, the court is able to relax the rule. In several cases, for instance, the Supreme Court has held that the Court of Appeals enjoys concurrent jurisdiction with family courts in hearing petitions for habeas corpus involving minors, as we have discussed a while ago. Okay, here in this case, the two minor victims for whose interests the people wanted the murder cases moved to a family court are dead. Okay, as respondents aptly point out, there is no living minor in the murder cases that require the special attention and protection of a family court. In fact, no minor would appear as party in those cases during trial, since the minor victims are represented by their parents who had become the real private offended parties. Okay, general jurisdiction of family courts. Let us discuss the case of Garcia versus Drilon, GR number 179267, June 25, 2013. The issue in this case is whether the family court has jurisdiction to resolve the constitutionality of a statute. The Supreme Court held that at the outset it must be stressed that family courts are special courts of the same level as regional trial courts. Under RA 8369, otherwise known as the Family Courts Act of 1997, family courts have exclusive original jurisdiction to hear and decide cases of domestic violence against women and children. In accordance with the said law, the Supreme Court designated from among the branches of the regional trial courts at least one family court in each of several key cities identified. Okay, to achieve harmony with the first mentioned law, Section 7 of RA 9262 provides that regional trial courts designated as family courts shall have original and exclusive jurisdiction over cases of violence against women and children defined under the law. Okay, so, in spite of its designation as a family court, the RTC of Bacolod City remains possessed of authority as a court of general original jurisdiction to pass upon all kinds of cases, whether civil, criminal, special proceedings, land registration, guardianship, naturalization, admiralty, or insolvency. It is settled that RTCs have jurisdiction to resolve the constitutionality of a statute, and this authority being embraced in the general definition of the judicial power to determine what are the valid and binding laws by the criterion of their conformity to the fundamental law. So again, this is similar to our discussion regarding courts of special jurisdiction. So notwithstanding the fact that an RTC is designated as a special court, such as a family court, it is still vested with general jurisdiction. And under the general jurisdiction, it can pass upon the constitutionality of a statute. Thus, contrary to the posturing of petitioner, the issue of constitutionality of RA 9262 could have been raised at the earliest opportunity in his opposition to the petition for protection order before the RTC of Bacolod City, which had jurisdiction to determine the same, subject to the review of the court. In cases where there is no family court, what should be done? So, in cases that there is no RTC branch designated as family courts, the case shall be raffled among the branches of the regional trial court within the same station, which then shall try and decide such cases according to existing issuances. However, The branches of the regional trial court in these stations, which have previously been designated to try and decide juvenile and domestic relations cases and cases involving youthful offenders, shall continue to take cognizance of such cases.